What is a trust? Before I jump right into the explanation as to what a trust is, I want you to imagine the following. You're flying on an airplane far, far away. The flight is 30 years long, and you've just celebrated your 50th birthday. Your son has promised to meet you at the baggage claim when you arrive, and he'll help you with the 2 bags you've checked. We'll come back to this scenario in just a bit. But first, hello, my name is Wilha. I'm a California licensed estate planning attorney. I do wills and trusts, and I help people avoid the probate process. When I work with clients or talk to them for the first time, one of the biggest hurdles they face is understanding what a trust is and how it's different from a will. The difference isn't very intuitive, and the misconceptions lead to a lot of confusion between the two. Both documents operate in completely different ways to accomplish a similar end result, which is to give beneficiaries something. So let's start by defining what a will is. A will is a legal document that allows you to specify who should receive your personal assets. When you die with assets in your personal name, those assets have to go to probate court to be distributed, subject to creditor claims. This means that if you have a credit card balance with American Express, they can ask to be paid from the assets that go through probate. The will you've written must be submitted to probate court, and someone you've nominated will have to petition to start the probate process. In other words, the will drives the probate process, and it overrides the default rules of probate. If you don't have a will, then the default rules of intestacy will apply. Aside from specifying who should receive your assets, you also nominate who will serve as executors. They're responsible for starting the probate and seeing it through. They're also the person that typically hires a probate lawyer to assist. So that's a will. A will is to override the default rules of probate. A trust, on the other hand, is a legal agreement with a set of instructions for how to manage property that you've associated with it. That's it. So let me repeat this. A trust is a legal agreement with a set of instructions for how to manage property that you've associated with it. Because you can appoint people to take over this management once you're unable to, it's possible to use a trust to avoid probate entirely. If assets are held in trust, then they're not held in your personal name, and because nothing is held in your personal name, there's actually nothing to probate. When you create a trust, you transfer property to be held in trust by the trustee. For example, if it's a house, you transfer title through a deed. When you die, the successor trustee you've nominated takes over and distributes your property according to your instructions in the trust. A distribution can be made outright, or it can continue to be held in trust. You can even do some really restricting things, like restricting how assets can be distributed. This gives you what's sometimes called a dead hand control, or the ability to control assets from the grave. For example, you might give someone half the assets when they turn 25 and when they graduate from trade school, and then the rest remaining when they turn 35. I've heard of people describing a trust as something like an entity or a backpack that holds assets, but I don't think that's really a perfect analogy. Instead, I like to think of a trust as using the baggage claim scenario I mentioned at the start. The focus should be on the assets and the labels that show the ownership. To recap, you're boarding a 30-year flight, you've checked in 2 bags, and your son is scheduled to meet you. What I didn't tell you is that you actually die mid-flight. Now remember the 2 bags you checked in? Visualize one representing your house and the other one your checking account. Each bag has a tag noting who it belongs to. Now imagine that years ago you hired an attorney to help you with your estate planning, and they created a living trust for you. On the tag of the bag that represents your house, it says, Susan Smith, trustee of the Susan Smith Revocable Living Trust, or their successors in interest. You are Susan Smith. On the other bag, the tag simply reads Susan Smith. When your son gets the baggage claim, he's notified of your death and told that there are 2 bags that belong to you. Your son, being the nominated successor trustee of your trust, is able to take the bag representing the house because of the living trust agreement. For the other bag, the one made out to your personal name, the baggage claim attendant says that it has to be held in lost and found to determine ownership and distribution after any creditor claims. Because Susan Smith, the actual person, isn't around to claim it, it has to stay. What's happening with that second bag is exactly what would happen when you die with assets still titled in your personal name. That asset has to go through the probate process. This is a big reason why, even if someone creates a trust, if there's no follow through, assets can still end up in probate, leaving you no better off. So the main takeaway, the definition is that a trust is a legal agreement with a set of instructions for how to manage property you've associated with it. Trusts are property driven. If the trust does not have any property associated with it, then the trust is not very useful at all.